Chairman Cam, just let me know we're ready to start, and I'll be just IT to put this live.
Okay, should
We'll be
we,
missing two again today.
Yes.
Okay.
should we, oh, it's like according to that clock, it's, should we wait or can we start or?
It's 6 o'clock right now, but if you want to.
Oh, okay.
That's a little behind her.
Per Apple, it says 6.
Yeah, yeah.
Okay, let me, hang on just a sec.
There's no panic buttons under there. Everybody used to have them in Downey.
Yes, they should.
Oh, I think.
Thank you for waiting for me.
Of course, we wouldn't consider starting without you.
Do you have the timer?
Yeah, these are wireless. You can hold up.
Fred,
No, red means it's muted.
Okay.
So green would be, yes. Good evening. I call to order the Planning Commission meeting of today, Wednesday, October 19th, for the City of San Clemente. And we'll start with the Pledge of Allegiance. Commissioner Davis is going to lead us in the Pledge of Allegiance. If you'll all please stand.
ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Can we please call the roll?
Commissioner Crandall,
Here.
Commissioner Davis,
Here.
Commissioner McCacken,
Here.
Commissioner Prescott Leffler,
Here.
Chair Pro Tem Camp. He is not in attendance and gave us notice that he would not be. Vice Chair Cosgrove, he is also not in attendance and gave us prior notice that he would not be. And Chairman McCann.
Here. Thank you. We have no special presentations. Next item is the minutes of, we have 2 minutes. Minutes from the joint council meeting and commission meeting on August 31st, and the minutes of the October 5th Planning Commission meeting. I have a couple changes to those minutes.
I have to the second one.
Okay, would you like to address yours first?
The first one, the first set of minutes for August 31st, I don't believe I have any changes for that one. It will be for the October 5th, so we can, I'm fine with the August 31st. I don't remember opening that meeting, but
Okay,
it says I did.
that was going to be on the August 31st meeting, it says Commissioner Crandall called the study session to order. I believe I did.
I believe that's probably true.
So that would be my change on that one. Does anybody else have any changes on August 31st? Okay, on October 5th, Commissioner Crandall?
Yes, I am looking for the page here. Commission comments. I did comment that I was able to make the findings for the general plan amendment and the zoning amendment with no reservations, so I think that would be good in there.
I'd agree with that. I believe I concurred with that. And I have another change. Page 6.
The general plan and the zoning amendment.
Also on page 6, the very last bullet, agreed the percentage of affordable homes should be higher than 8% offered. According to my notes, that was true. However, I added without addition of concessions. So if we were reminded that if it goes to 10%, that additional concessions would be afforded, and I suggested that it should be higher than 8%, however, higher than 8% without adding the additional concessions.
Thank you. And then my comment is on page 2, item B, approval of the minutes. It talks about being moved by Commissioner Cosgrove and seconded by Crandall. Cosgrove wasn't in attendance, so if staff could please review and see who the appropriate parties were on that, that would be great. I guess I would make a motion to move approval of both of those sets of minutes, subject to the changes discussed.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed? Thank you. Next is oral and written communication. Is there anybody here in the audience who wants to speak on any item that's not on the agenda tonight? Okay, seeing none. Do we have any written communication for items not on the agenda?
Staff has not received any.
Thank you. Okay, moving on. Consent calendar, no items. 8A, public hearings. We have public hearing on the development agreement for the proposed senior housing and medical office development agreement. Do we have a staff report?
Yes, Chair McCann, Adam Matamian, Deputy Community Development Director. I will be presenting this item tonight. Jennifer Savage is not available, and I will do that on her behalf. So with that, the item before you is a development agreement for a project proposed at 654 Camino de los Mares Senior Housing and Medical Office. The request is for a development agreement for a mixed-use project with 254 rent senior residential units and a 7,500 square foot medical office. The subdivision of the one lot into two, rezoning the property from regional medical facilities 1 to community commercial 4, changing the general plan designation from regional medical facilities to community commercial. And it includes a request for shared parking and an increase in floor area and concession incentive waivers pursuant to state density bonus law. While all of those are aspects of the development agreement, the proposal before you tonight is specifically just for the development agreement, which would stipulate that the applicant is required to obtain all necessary approvals, permits, and entitlements to allow the proposed project, including the general plan amendment, zoning amendment, subdivision of the lot, and constructing the proposed development. The required findings for a development agreement are located in the zoning ordinance section 1716-230 and government code section 65867.5, and those require that the provisions of the agreement are consistent with the general plan and any applicable specific plan, and that the agreement provides that any tentative map will comply with the government code section 66473.7. So this item is before you tonight due to a noticing error from the previous Planning Commission meeting where the development agreement was not included, and so it was pushed off to this meeting. The staff report identifies the general plan consistency findings supporting the applicant's request for a development agreement, and the resolution that's attached as that's attachment 1 also includes those findings as well. The applicant is here and may wish to speak on this, and with that I will conclude staff's presentation and state that the recommendation is to recommend determining that the proposed addendum to the EIR number one, recommend determining that the proposed addendum involves only minor technical changes to the 2021 FEIR and would not result in any new or increased severely significant environmental effects beyond those identified in that FEIR, and to adopt Resolution PC 22-023. And that concludes staff's presentation. I am available for any questions. With me tonight is Cecilia Gallardo-Daly, our acting interim city manager, who can also answer questions on this.
Thank you. Would Adam, do you know if the applicant wants to make a presentation?
Just briefly.
Sure.
Good evening. Our understanding is that this is largely a procedural matter tonight. We obviously had the lengthy discussion at the October 5 meeting, so we're certainly not here to repeat that. But we understand that in order for this to go to council, this is something else that needs to be addressed by the Planning Commission, and that the council's preference is to have the entire package before it when it considers the matter. So since we met on the 5th, we've been working with our design team to address many of the comments that you provided and that others provided from the public. And so we're continuing that effort in the hopes of being able to address them in more detail at the council. But I'm happy to answer any questions or address anything that the commission would like. But really, our understanding is this is largely a procedural requirement this evening.
Thank you. As long as Mr. Leary is at the podium, does anybody have any questions for him specifically?
Yeah, in the agreement, there's a lot of discussion about the senior housing, but nothing about the medical office building.
Greg, is that correct? Our counsel's here. I thought there is a reference in there about the medical office
No,
building.
I couldn't find anything about,
There is one reference to the medical office building as being a part of the entitlements, but there's no discussion of the medical office building.
okay.
Yeah, I guess one, to further respond or clarify, the development agreement that I believe was included in your package for tonight was the form that would have been presented on October 5. So for example, on the affordable housing component, it references the 5% number instead of the 8% number that we talked about on October 5. I think that was intentional, simply to maintain consistency with what was submitted and not to go in and start making those changes, but we understand that particularly if we're going to be responsive to the commission's comments, or those that we can be responsive to, that there will be edits to the development agreement before it goes to council. Some of that will affect the development agreement, some of that might affect the conditions of approval, but that's what we're working on right now and working with staff and engaging with them to see how that can. So there may be some inconsistencies. The obvious one was the 5% number. We stand behind and are committed to the 8% as we talked about on October 5th.
Any other questions for the applicant? Thank you.
Thank you.
Go ahead.
Chair, we do have 2 speaker cards on this, and if you'd like, I can call
Okay,
them out.
let's do commissioner
Before we open
questions.
that, I do have some
Yeah,
additional questions.
yeah. Does the commissioners have any questions for staff?
I do. This is for Mal. The development agreement is just strictly what it says. It's an agreement between the city and the applicant, but it is not required to approve the rest of the project. Is that correct?
That's correct.
This is supplementary to it.
That's correct.
Okay. And I was curious, are you aware of what the process was of negotiating that agreement? Who was involved?
I was not
in it?
involved in the process, but I know generally that staff and their opposites with Memorial Care were involved, the attorneys for both sides were involved. It was a months-long process. Again, I was not directly involved in the process, but staff and management from San Clemente and the attorneys from both sides were involved in drafting it.
Okay, so once the agreement is made, if the state changes their rules, this doesn't affect them having to comply with new state mandates?
Well, a development agreement, yeah, it's a good question. A DA vests the project applicant, in this case, when they're granted permits, the permittee, as against local regulations, but we don't have anything to do with state regulations. So if the state changes things that could affect the project or the city, we can't contract around the state's potential to change those regulations. So the answer is no, we cannot vest them in a DA against changes in state regulations.
Well, my example would be if they change, right now, they have a section in there for senior housing with 5% affordable. If they drop that and make it 10% or something higher, would that apply to this project?
They being the state. So if the state changes what is legally required, yeah, if that requirement is adopted before certain approvals are granted with this project, then we'd have to apply or comply with those requirements from the state.
Yeah, I'm looking at, if they say you don't get the density bonus unless you have 10% or some other number than the 5 that they have now.
It depends on how that law would be drafted, but yeah, potentially.
Okay.
Thank you.
I did want to mention on page 4, the consistency findings on the second paragraph to the right. It says the project would construct new medical offices and support the enhancement of health care facilities in Camino de los Meros area. So it does mention the medical facility in slightly.
This is in the staff report,
Right.
not in
Not in the,
the agreement.
I'm a little concerned about that. That is not in the,
We'll do that during discussion.
okay.
Yeah, I'll just throw my questions out now. Oops.
Mr. Chairman, maybe I can help out. If you go to section 2.2 on page 11 of the development agreement, you'll find medical office building.
Okay.
11 on my copy.
Thank you.
You bet.
Go ahead, Commissioner McCacken.
On page 9, it says the definition of owner means Memorial Healthcare Services, but then for owner, on page 30, it says Saddleback. So our definition is owner is Memorial Healthcare Services, but signatures and where copies are sent is to Saddleback. It even says if to owner, Saddleback. Any comment on that?
I guess that's a Mal question, probably.
Yeah,
And I'm noticing this, Mal, I'm also noticing that the signature block says Saddleback.
right.
I think that's a good catch. The owner is Saddleback, and that should be the signatory. That's probably just a holdover from a prior draft. So that was something that would be fixed in the final. But,
Does Memorial own Saddleback?
Yes. Yeah.
So the true owner is Memorial. Okay. I'll just go through where I've term, that's the definition, but that's one question. Why 20 years? And it brings up the question, if if a building permit is issued, when does it have to be exercised before it expires?
So in terms of the term, this really gets to a question of vesting. So the proposed term here, the vesting length is 20 years. As to your second question with the building permit, what matters is whether there's anything spent in furtherance of that building permit. So whether or not the building permit expires, once a building permit is pulled, right? So let's say that the application is approved by the council, hypothetically, right? The DA is passed by the council. Once that building permit is pulled and any amount of money is spent in furtherance of it, this DA will vest for 20 years, as currently written, even if nothing further happens. That's pursuant to case law. So the building permit could lapse, but because money has been spent in furtherance of that permit that's been pulled, the vesting's already happened.
So when the building permit expires, then what happens?
Well, in terms of that building permit, it expires, but the DA would have vested already.
Okay, but then they would have to get another building permit?
Sure.
And the same expenses again, and,
I assume that's more a question for the building department, but yes, as far as the DA goes, once that permit is pulled and any money is spent in furtherance, then you have the vesting that's triggered.
how many other 20-year DDAs does the city have?
Oh, I couldn't tell you. I don't know.
One? None? Could be interesting. Why would the city give 20 years?
The 20 years is what the applicant is proposing. So similar to other applications, this is a request made by an applicant, and we're reviewing it.
And how does the 20 years affect the $15,000 a month maintenance fee?
So any fees in the agreement would be applicable for the life of the development agreement.
So we pay $15,000 a month to maintain the landscaping of the property once the DDA, up until the DDA is approved? Because section 2.1 is the longest sentence I think I've ever read in my life. There's only one period in that whole, and that's at the very end of that paragraph. Can you explain section 2.1 to me?
I apologize for the lack of the period in there. We'll see if we can fix that one too. But there may be a misunderstanding of the relevance of that provision. There's a provision in the litigation settlement agreement dating back to 2019 that if the city hadn't rezoned the property by a certain date, then the city from that point forward would have to reimburse our organization for up to $15,000 a month for maintenance and security costs.
So we're not paying that now?
You have not, the city has not been paying that, and we've been operating under, at least through January of this year, we have waived that provision because we've been working closely with staff to try to put together a project that would be approved and would eliminate the need for that. The proposal and what the development agreement reflects is that once this development agreement is signed and once all the entitlements have vested, what Memorial Care is doing is waiving that provision in its entirety, both backwards and forwards. So there would no longer be any obligation for any prior periods or any future periods relative to that. Because the whole point of that provision in the settlement agreement was to create an incentive, if you will, to make kind of a final decision on how are we going to resolve this. So with the resolution that would be reflected in the development agreement, that provision of the settlement agreement would go away.
So if there was a referendum and the DDA or the project was denied, what happens to $15,000? Then we have to start paying $15,000 a month?
Absent under the terms of the settlement agreement, that would come back into play.
It talks about the owner waiving. So that's where I get confused at the very end where it says the owner waives the right to collect the $15,000 a month. if none of those things above happen?
Correct.
If you don't lose your entitlements without your consent to have the project go forward?
Correct. Once the
If state law changes, you can consent, okay, that's all right, we're still going to go ahead. You know what I'm saying? Because it says, it's talking about anything that could possibly happen. Moratorium, suit, appeal, administrative,
Correct.
loss of entitlement, everything.
Correct.
So if you lose any one of those things, what's the operation of this waiver 2.1?
Then we would go back, the provision that's in the 2019 settlement agreement would basically be operative again, and we would have to deal with it under that provision,
And we may have to start paying $15,000 a month to maintain the property.
unless the city otherwise complies with the obligations under the settlement agreement to return the zoning to what it was prior to the decision to spot zone. That's correct.
So if the state changes their rule, whatever the rule might be, that the city, being a secondary power, has to follow and change their building code, right? That's
Not
possible.
entirely. So the way section 2.
But partially.
Well,
And if their
no.
building permit had expired, then they would be subject to the new California regulation and the building code.
The way section 2.1 works is the obligation to pay the 15,000 or not pay it hinges on the granting and the vesting of the entitlements, right? So assuming the council would approve these entitlements, again, that's the hypothetical we're playing with. So if the council approves the entitlements and there's no referendum, there's no initiative, anything to overturn that, regardless of what the state does, those entitlements have been approved, right? And at that point, the $15,000 per month is gone,
Okay.
period.
But what about this thing of building permit? If the building permit expires
It doesn't
before
matter.
they
We've
exercise their
entitled.
entitlements,
So once we've entitled this property, right, assuming that the entitlement goes forward, regardless of what they do with their building permits, the $15,000 per month is eliminated pursuant to section 2.1 because the DA would be in effect.
even if the state passed some law that cities have to follow,
That's correct.
that would grant them through their entitlements something more that's legally allowed under the law at the time of the building?
That's correct, because the only obligation that we have as a city, in order to push away that $15,000 per month obligation, is to entitle this property and to have that entitlement remain effective, right? So no referenda, et cetera. As long as we do that, then the $15,000 is gone, regardless of what the state or any other agency or entity would do.
Is that pretty routine to allow entitlements for 20 years?
It depends on the DA. I have drafted probably a dozen DAs with vesting periods of 20 years. I've also drafted DAs with 5 years, with 10 years. It just depends on the project. It's a negotiation.
Yeah.
So there's a range from just a few years all the way to 20 years. I've seen all of that.
Because in my experience, I've never seen that long of a term. Usually it's around 5 or 10, even with gigantic properties like Boeing properties being reused. Okay, let me keep going through what is party construction case?
I'm sorry, I didn't catch that. Which
Party
section are you in?
Construction Company versus the City of Camarillo, 37 Cal 3D 465, 1984.
Yeah, which section are we
I'm
in here?
on page number 12, but it's mentioned probably half a dozen times in the agreement, so that we don't result in Party Construction Company versus City of Camarillo. Anybody can chime in.
I can answer that for you.
Yeah, it's
That
2.7.
just immunizes the development agreement against an initiative or a referendum.
Immunizes it?
Yeah, that's correct.
So if there was a referendum cannot be allowed even if it was successful?
Well, a referendum can be allowed, but if it was successful, it would not apply to the project
How's that possible?
because there's a contractual relationship between the city and the property owner that provides that the city cannot change the zoning, general plan, et cetera, And that period lasts for a period of 20 years in accordance with the way it's presently written.
So your argument is that it takes away one of the rights afforded most California communities to have referendum of an ordinance?
Well, the theory, sir, is that the people don't have any greater power than the city council. So if there's an initiative or a referendum
But
that
the
is...
people are the sovereign.
I understand that, but in terms of the legal wherewithal that the people possess, their powers are not greater than the powers of the city council. So in terms of enacting land use entitlement ordinances, for example, the people can't do anything that would contravene state law. They can't do anything that would contravene a city ordinance, and they can't engage in impairment of contracts. And that's what an initiative like that could do.
Could do, but like I know in some cities, referendum have stopped the building of court buildings because the city was involved in the property.
Well, that may be, sir, but perhaps there wasn't a development agreement. If there was a development agreement in place that had the same provision that this development agreement has, and that most development agreements have, then it would be beyond the power of the people to enact an initiative or a referendum that would contravene the provisions of the development agreement.
Because in a city that I lived before, by referendum, people completely dissolved their redevelopment, or the ability to use eminent domain. Huh. Well, I don't know, I'll have to read that case.
Okay.
I don't really like that being in it. That makes us like a substandard, and then we're giving that right away, the people's right away for 20 years, that they can't object to it.
Just
Yet they
a,
could,
just a quick note, this is boilerplate DA language. This is in every DA that you'll ever find. So, I mean,
that
it's,
you'll ever find since 1984?
well, since this is in every DA that I've ever seen. This is just boilerplate development agreement language.
Mal, could you clarify if it's boilerplate for 20 years?
So whether it's a 20-year or a 5-year vesting or a 3-year vesting, this is a paragraph that you find in every development agreement. So the one, again, I've drafted probably a dozen at 20 years. I'm not defending but this is standard language.
But just to clarify, so this would avoid any type of public initiative if there was objection?
It attempts to do that. It tries to avoid the result that occurred in this case.
So if the public wanted to launch an initiative and gather signatures and put something on the ballot, because it's part of their city, this would, for 20 years, prevent them from doing such.
The public would certainly be able to do that. They only have a very short period of time after the approval to do that. So it wouldn't prevent them for 20 years. That initiative period is only for a very short window of time after the approval. So let's say that the council approves this hypothetically in a month. The public would only have a set number of days to gather signatures in order to bring that initiative. So this wouldn't apply over the 20-year period. It would just attempt to apply during that short period.
Thank you.
Will this be adopted by resolution or ordinance by the city council?
DAs are adopted via ordinance.
So it would not be subject to referendum, even if it was, if there was a petition within the first 90 days or whatever it's allowed.
No, it
Because
would be...
ordinances are referable.
It would be subject to referendum. The ordinance is subject to referendum for the 30-day window
Right.
after the city council approves the development agreement and adopts the ordinance.
So
But
during
after that, then any initiative or referendum that is inconsistent with the development agreement would not be effective. It may affect other properties, but it would not affect the property that is the subject of the development agreement.
Okay.
Sir,
I don't know.
It's just the same as if the city council adopted an ordinance that was inconsistent with the development agreement. There's no difference.
I'm just saying an ordinance in general, because hopefully the ordinance is consistent with the DDA, but I've never heard of immunizing any ordinances or referendums, actions of the council from a public plebiscite.
I understand. You were asking earlier, sir, about whether or not there's another development agreement that the city has entered into that is for a period of 20 years. I represented Talega Associates. I negotiated the development agreement, in fact, 2 of them for Talega Associates. My recollection is that both of those development agreements were for a 20-year period, and both had the same provision in them.
Okay, let me find my next question. The annual review, it's page 23, section 12.1. And will this happen until the building is this something that will be ongoing as long as the building is not built?
So annual review of a DA is required by the government code, and it's embedded into every DA until the development agreement is no longer in effect, which usually happens once the development is constructed, right? And then the parties will agree that the DA is no longer effective. That annual review is required to happen. So yes, until the building is constructed and the DA is no longer in effect, the annual review will happen. And the way that review happens is the council reviews the DA for substantial compliance with its terms by the developer.
Those are my questions for right now.
Thank you. Anybody else have questions for staff?
So typically when you're, when this is going on, I'm just trying to understand who's in the room when things are getting, is this a negotiation that's happening? Like, so, meaning is it the applicant and personnel from the city with no, I'm just trying to understand how you guys are getting to this. It feels like a little bit of a negotiation, but there's nobody from the planning staff or the city council involved. It's staff, am I right?
Yes, that's how a development agreement is negotiated. So you have planning staff, you have management, and then you have staff from the developer along with the attorneys. It's negotiated because it's a contract. It's a contractual agreement. Then the draft terms are brought to the planning commission and council, which is what's happening right now. So nothing is set in stone, but that negotiation happens with staff from both sides with the attorneys, and then it's presented to the planning commission and council.
So attorneys from both sides are there, I presume?
Yeah.
And then, is there concessions generally given from the applicant to the city to adopt this, or have we gotten anything, really?
There's typically a give and take that happens.
What's the give?
With DAs. What's the give from
What
the
did- what did
developer?
the
I'll
city
let
give?
them speak to that first, and then I can chime in.
Okay. Because I see 5%, I see 20 years, I see a lot of take.
Well, Commissioner, first of all, the city gets relief from the provisions of the settlement agreement. So there's $15,000 a month that accrues to the city's side of the ledger. Secondly, under the density bonus law, the developer is entitled to all the provisions of the density bonus law, whether or not there's affordable housing built with this project, because it's a senior citizens project. So we are giving the city a significant number of affordable units in conjunction with the project, so that goes on the city side of the ledger. And we think those concessions are very material.
On that side of the ledger, the public has chimed in and is all excited about an urgent care, about health care, yada, yada, but the building, the medical building is always just called medical office, which doesn't require a conditional use permit, regular offices could go in there. There's nothing in the document that says what this really is.
Well, I think the record, sir, is very clear on what it will be. It's designated as a medical office building in the development agreement, and if it's used for any other purpose, then the property owner would be in violation of the development agreement.
I mean, there's one medical office in the building and 14 regular offices? I mean, there's no definition of what it
It's
is?
a medical office building. I mean, I think.
That's why I was worried. It's only mentioned, you found one spot that's mentioned.
A reasonable interpretation of medical office building, I think, is that the entirety of the building would be devoted to medical office purposes.
Would that be obligated in perpetuity or just until that was constructed?
For the 20 years of the development agreement.
So if you start building it in 2 years, finish it in 3, then is the DA still in effect for the next 20 years? Because I would think it would kind of be accomplished once you were done and occupied with the CO.
No, sir, the development agreement remains in place for 20 years. It's recorded and it runs with the land. So it binds not only the present property owner, but all future property owners.
Thank you.
You're welcome.
Real quick, staff, is there a reason to really rezone this prior to their other project getting approved? Because it feels like, I don't know, I'm just trying to understand that. Because we're rezoning something based on their other project. I understand they're different. Does that make sense?
Just to clarify, you're talking about rezoning the property before, separate from
Yeah,
the
'cause
actual project itself?
Yeah, I think that's what I'm saying, because we're rezoning this, right? This is a different development agreement, but then their project's not approved?
No, so there's there's a couple aspects here made up of a number of applications. The one before the planning commission tonight is just in reviewing the development agreement.
Yeah.
And then there's what I'll call the project applications, which are to change the land use designation in the general plan, change the zone on the zoning map, and to provide the entitlements to actually construct the building and provide for the uses that they're proposing. That is all, being proposed together, so there's no separate zoning. What's before you tonight discusses that project because that project is part of the applicant's, I'll call their give in the development agreement, but it's not, this development agreement, and nor is any decision you make tonight, make a recommendation to rezone this property. That was discussed by the planning commission at the last meeting, and those other applications were denied. Or, I'm sorry, they were recommended for denial by the planning commission.
My train of thought has wandered here for a second. I'm confused on the 20-year lifespan. If they build in the 18th year, how long do they have to keep the medical office building a medical office building? The way you stated it, it sounds like 2 years.
That would be correct. If it was built during the 18th year, then whatever time remains until the expiration of the development agreement, the developer would be, the owner would be required to maintain the building as a medical office building,
For 2 years.
whatever time is left, 2 years.
Okay.
Year and
So
a
the
half,
benefit
whatever.
to the city diminishes every year that transpires, as far as the benefit of having a medical building.
I suppose you could.
If you
look
build
at
on the
that.
first year, we get 20 years. If you build, it diminishes each year. Okay, pretty good.
Can I clarify that? So I was under the assumption that the two projects would be built in tandem, so there's no requirement for the two projects to be built at the same time?
No, no, ma'am.
Okay, thank you. I have one more question on page,
Except for the parking.
except for the parking,
So one can't be built without the other.
without the other.
That's right.
Page 20, on attachment 20, 9.5, force majeure extensions. Can you tell me, under the example of why the extension would be needed for a force majeure?
Well, I suppose, ma'am, if there was a devastating earthquake, for example, and the project had not yet been constructed, that it could take many, many, many years for the community to recover to the point where the infrastructure is in place and the property is developable.
If we had a situation where the pandemic spikes again, would the force majeure be able to be triggered at that time? If construction was delayed?
If there was a nexus between the pandemic and a delay, then the answer would be yes.
Thank you.
Anyone else have any questions?
One last question for Mal. Mal, did you receive the, I think it's 177-page letter questioning the CEQA and EIR findings?
Have I received that?
Yeah.
I've seen that, yes, and, yeah.
And since it's part of our package today, does that affect the staff's recommendation of approval of the negative, well, it's not a negative deck, but it's
They are addendum.
saying we were exempt from,
Yeah, it's the addendum. No, we're confident with the approach that's being taken by the city for CEQA clearance.
okay.
May I add to the comment, sir? In addition to the procedure that the city has followed being rock solid, the statute of limitations is passed on any challenge to the EIR that was certified for the housing element. So we don't see any chance of a successful CEQA challenge.
I have a question or two. What would constitute, Mal, kind of fulfilling this DA? Like if they pull a building permit, if they get a C of O, what would be, what would make it kind of, I understand it goes in force immediately, right? But then what would kind of say, okay, we've now achieved the the DA?
Yeah.
Is it the expiration of the term?
Yes, that's the ultimate achievement. That's how a DA comes to conclusion. The parties can agree prior to the 20-year term to conclude a DA. I've been part of a handful of DAs where both sides have decided to end the DA before the term ends, but that requires an ordinance adopted by the council under the equal dignities rule, where, this was adopted via ordinance, it needs to also be ended via ordinance. It takes some work to conclude a DA. Many DAs, it's not wise for either party to conclude the agreement before the end of the term because the parties still benefit from that term. The DAs that I've been involved in where the term ended prior to the 20 years, the 15 years, whatever it was, were ones where the public benefit was achieved in the first few years of the DA. The construction was accomplished in the first few years of the DA, so the vesting wasn't required anymore. The city no longer had a need for the DA, and nobody wanted to go through the hassle of the annual review. I won't say it's rare. With a project like this, it probably is rare, where I think both parties would benefit from having that term run its length.
Okay, thank you. Regarding the 15,000 monthly maintenance, that gets severed upon rezoning of the property. Is that correct? Not about approval of a project,
Upon granting of the entitlements that are being requested. The entitlements are defined in the agreement, and so the granting of those entitlements is what triggers, and then the passage of any referendum period, right? So the cementing in place, if you will, of those entitlements is what triggers the elimination of that $15,000 a month payment.
Okay, because I was understanding it was just the rezoning back to the prior zone.
So
Okay,
the entitlements as defined are the general plan amendment, the zone change, the vesting tentative map, architectural permit, site plan permit, and conditional use permit. And that's what's referenced in the section regarding the $15,000. Once those are granted and they're firm in place and no longer challengeable, then that provision is operative.
what section is that? Is that in the DA or in the settlement agreement?
That's in the DA.
Okay,
Entitlements are defined in the definitions portion.
Okay. Do we have any speaker cards?
Mr. Chairman, before you go on to the hearing, may I explain why 20 years is the norm in development agreements?
I wish you would have done that in your original presentation or offering, but briefly.
Sure. Let's suppose that the development agreement was for a period of 5 years. At the 6th year, then the city is free to change the zoning, change the general plan amendment, or change the general plan by amendment, and take other actions that would render the uses at the property legal non-conforming uses. And under almost all zoning codes in California, if there's significant damage or the need for remodeling, an addition, et cetera, the city, by its own ordinance, would be powerless to approve repair of the damage, et cetera. Anything that would require a discretionary permit, the project would be at risk.
Mel, do you agree with that? I guess I'm confused, because if they build the project within whatever the term is, let's say it's 5 years, the project is built, then it seems to me that that would only be the case if the project isn't built, or they try and build it after the term expires. But once it's built and it's legal conforming, even if they change it afterwards, it's still built and is allowed to stay.
Yeah, it can stay. If the city, however, would change the zoning after it's built, then it does become a legal non-conforming use or structure, and then it would be subject to our legal non-conforming use language in the code, which makes it very difficult for those types of uses, legal non-conforming uses, to expand, to change uses, et cetera. So it just ties the hands of a use once you become legal non-conforming. So the legal non-conforming status only happens once something is built pursuant to the then existing code, and the code is changed after it's constructed.
Okay, so the only point he's raising, I guess, is that when is that scenario a possibility, whether it's after 3 years or 5 years or 10 years or 20 years? But that possibility exists at the termination of the term, whenever that is.
That's correct.
Okay, so it's
Yeah.
not going to make that an impossibility, it's just going to forestall that as a potential
That's
out.
exactly right.
Okay.
Yep.
Thank you.
You bet.
I'd like to now open the public hearing on this issue.
And Chair McCann, we have 2 speaker cards, and I will read off the names. If there is anybody that would like to speak that has not filled out a card, cards are available in the back of the room. Please fill one out, and you can bring it up to the table here. So the cards that we have, the first speaker is Stuart Anderson, and the second speaker will be Thomas Miller. And I will start a timer. You'll have 3 minutes. The light will turn yellow when you have 1 minute left.
Planning Commissioners, good evening. My name's Stuart Anderson. I'm here I'm a San Clemente resident of 18 years. I'm here on behalf of myself and also as a spokesperson for the San Clemente Affordable Housing Coalition. We are in support of this project. I'm speaking tonight only regarding a small aspect of it, and that is a 20-year duration of the development agreement. Understand there's some anxiety about that. 20 years is a long time. However, it's my understanding that clause is only there in case some unexpected catastrophic event emerges that delays construction. Delaying construction is not in anybody's best interest. It's not in the city's interest. It's not in the developer's best interest. And we believe that it's very unlikely that development will be delayed for 20 years. And so we urge you to please don't let the 20-year portion of the development agreement inhibit your recommendation to recommend this project that will bring great benefit to the seniors of San Clemente with the housing portion and to the greater community with the medical building. Thank you.
Thank you. Thomas Miller?
Miller?
Before I'm starting, could I ask one question?
Unfortunately, this is not a Q&A
Okay,
thing. If you
okay.
raise, you're allowed to, I don't think your timer's started yet. You have 3 minutes to talk.
Okay.
You can ask 1,000 questions. We're not supposed to engage in a back and forth dialogue with you.
Okay.
Although if your question
Okay.
piques our interest enough, we may then ask it after the fact.
Okay, it's not involved in my thing, it's just when I was listening to everything going on here, it came to mind. I guess it's just my misunderstanding of what a development agreement is. So, okay, I'll start my section. I'm Thomas Miller. I live at 2 Cresta del Sol in the Sea Point Estates. The neighbors who have participated in these memorial care meetings and subsequent committee discussions would be in favor of development of the 654 Camino de las Maris property and the additional senior housing. However, the size and scope of the project would appear to be too large for the location considering density, parking, traffic patterns, and the neighborhood's atmosphere. Also, Memorial Care's long list of requested variances, for example, the height variance alone may set a troublesome precedent for future projects in the community. Since Memorial Care closed our hospital, it became necessary to travel to the hospital in Mission Viejo for emergencies, creating potentially a dangerous situation. At certain times of the day, the traffic on the I-5 freeway increases significantly. These delays create a danger for our seniors who generally need to have hospital attention as quickly as possible. We are being asked to consider a project which will considerably increase the congestion on Camino de las Maris and result in further
Hang on,
delays
Mr.
in
Miller,
as
hang-
ambulance.
Mr. Miller, hang on for just a second. It doesn't seem to me that he got his full time. Was that started while we were kind of discussing things? Because I saw that yellow light come on right away, pretty much.
Once it's turned, once it's beeped, it did seem a little quick.
Well,
But this is set for 3 minutes. I really can't say. If you'd like to.
I don't have that much longer.
Yeah, I think your timer got somehow shortened, so why don't we give you approximately a minute left?
Okay. Because it could increase the congestion on Camino de las Maris, resulting in further delays, as ambulances could easily get stopped due to this reconfiguration of the new center medians. And as we know, there's only one ambulance available from the fire station at Camino de las Maris across from Marbella. This seems like a lot of additional stress on the access to emergency hospital care affecting our elderly. The project will add at least 300 San Clemente seniors to the numbers living at San Clemente Villas by the sea and our neighbors in Sea Point. That is a lot more people struggling for timely hospital access for strokes, heart attacks, falls, etc. We are being asked to consider making an already difficult and potentially dangerous situation worse. Given the scope and size of these issues, we are asked to consider action that could endanger the very people some insist they are taking care of.
If you could
In
please wrap up.
conclusion, I think that further study and analysis is warranted before a decision can be made on the scope and size of this project. San Clemente will live with the effect of this decision for years. Thank you for your attention. Let's ensure that our San Clemente projects always improve the city and the lifestyle of our residents. Thank you.
Thank you, Mr. Miller. Are there any other questions or anyone wanting to speak on this topic? Sir, please come forward. Yeah, it looks like you have a speaker card.
Yeah, so I wasn't sure where to submit.
Just right up here. It's great. And you have 3 minutes.
Good evening, Commissioners. My name is John Tafoya. I'm a member of the Southwest Carpenters Union. I live in Orange County. We've got over 4,700 union carpenters that live in the city and the surrounding cities here. I'm here to ask that the commission make a couple of recommendations for this project. One, that there's some kind of a language implemented into the agreement that a local hire requirement. We've heard about traffic congestions, nowadays emissions. Like I said, we've got a lot of carpenters that live here and in surrounding cities that got to do a 2-hour commute to Los Angeles to work, 2 hours commute to the Inland Empire. We ask that there's some kind of language in here that gives our local carpenters priority to work in our cities, in our towns, to where we live here, we work here. Instead of having to do that 2-hour commute to and from work, working locally would give the opportunity of our members to make it home on time to see their kids' practices, their recitals. It's been implemented in other cities. By doing so, it, again, gets us close to home, lowers the emissions nowadays. You know, the emissions, pollution is a big issue. And then the second thing we'd ask to recommend is implement a skilled and trained workforce from a state-recognized apprenticeship program. Again, a collaboration with local high schools, get our kids from this city, from local cities, straight into a trade school. If they're not going to be making it to a 4-year college, the trade schools is a really, really good second alternative to a 4-year college degree. So those are the two items that we're asking that those recommendations be made for this agreement. Thank you for your time.
Thank you very much. Is there anyone else that wants to speak on this issue? Seeing none, I'll close the public hearing and bring it back for commission discussion.
I just have one question. Maybe, Mel, you can weigh in on this. So the 20 years has been explained that possibly catastrophic events, whatever, wouldn't the force majeure cover that?
I'm not sure I caught the last part before. Wouldn't the force majeure cover that? I
The 20
apologize.
years, the reason for the 20 years was the long term to mitigate a catastrophe, something that would delay construction, but wouldn't the force majeure preempt that or be used for something like that?
Yeah, it wouldn't preempt it. It would be added on to it would extend the 20 years for as long as that force majeure was in place, right? They'd have to request that the force majeure clause applied to the DA, and
Applied
then we'd
to
have
it,
to agree
okay.
to some term that force majeure would be in place. 2 months, 3 months, 6 months, depending on what the act was that delayed the project.
Okay, thank you.
Anyone want to lead us out or share their thoughts?
I'll get us started. Something I've always been concerned about on this project was the fact that we really have two projects on the site. We've got the senior housing and we've got the medical building. And it's been designed and tied together where you can't have one without the other. And the biggest benefit to the current population is the medical building. And with the development agreement, this is our first chance we've had to negotiate with the applicant. We were mandated by the state to acquiesce to their standards on the density bonus issues and all. The project can be built without a development agreement, with no problem. But it's to their benefit, obviously have it, and we want to work together with them because we want the project to be successful. And I really feel to be successful, the two buildings shouldn't be dependent on each other. In other words, if they find that they can't find a buyer who will either buy or manage the seniors building for 10, 15 years, but they want to build the medical office building prior to that, this doesn't let them do it. It's not flexible enough to, with the parking, shared parking and all, that'd be really difficult. And we can put something in or request that it goes to City Council to include the requirement that the two be able to be developed separately, which I think would be a big benefit for the city. It may not, tying the two together, I'm assuming they're going to get a builder to take the whole thing on and build the building for Saddleback, the medical building, and then operate the senior on their own. Mal, do you have a thought on, I mean, if we got rid of the shared parking agreement and let the commercial one stand alone with enough parking, it's big enough to have the parking, it would reduce I believe it would reduce the size of the lot for the senior building. But with the density bonuses available to them, it doesn't say they can't have the units because we aren't approaching the limit of the density bonuses. It just means they'd have to comply with the parking. Is that something that can be negotiated within a development agreement?
Yeah, it might be a better question answered by a planner, but it's not, when you're getting into the details of the actual plan, of the actual site plan, those typically aren't part of the development agreement. They can be referenced in the DA, but typically those stand apart from the DA, right? The entitlement package will be separate from the DA, albeit linked, but you typically don't deal with those kinds of details in a development agreement. They can be separately, we'll say negotiated. It's really a discussion between the applicant and the city, but that's really part of the entitlement package that was forwarded to council last time. But you can certainly still give recommendations regarding that.
To city council to
Sure. I mean,
consider requiring
it's not, it's not on this evening's agenda, so we have to be careful what kind of recommendations we're giving. That said, the DA is on the agenda, and that gives us some latitude in making recommendations. However, we typically don't design a project or reconfigure a project in a development agreement. It's not really what it's used for.
Okay. And then, for discussion, not everyone was here at the last meeting when we looked at the project standalone. We each had separate and sometimes common reasons for denying it. If this is in complete alignment with what we voted on last time, I'm not sure I can figure out a way to vote for approval of it if the project didn't change per our comments previously. And if you can talk me out of that, that's great.
My suggestion, Commissioner Crandall, would be that, so your comments and all of our comments are already on the record. And so it sounds like you're saying, hey, I don't see how I could recommend approval if those things aren't incorporated. My suggestion would be that at a minimum, you share your thoughts. And it doesn't have to be the second, we can come back to or whatever, but about the development agreement specifically. Because we already know and those will get communicated to council, so the council can have the benefit of your thoughts, but they don't have the benefit of your thoughts on the DA itself as a standalone. So they already, hopefully, reading the staff report and watching the video will know your thoughts on the other stuff, but if you have thoughts specific to the DA, and this goes for all of us, I think council would be benefited by hearing your thoughts on those. So, if that makes sense.
Sure, I guess with the resolution, I can't make the findings, if I couldn't make the findings before, I can't make the findings now per the resolution. But I've certainly got tabs galore to go over specific things, but we've all hit them slightly already. So I think I'm still curious how, Mal, we can say in one place in the, I think it's in the development agreement, that the low-cost housing units will remain for 40 years or some number. I think 50 was battered around, whatever. But on other things, they disappear in 20 years when the development agreement expires or is completed.
So affordable housing is deed restricted. And so that deed restriction will be on title. Those are actually complicated agreements. And that is, so while the DA will have a life of 20 years, one of the aspects of this project and the DA is a requirement of affordable housing with the covenants that are associated with that affordable housing, which covenants in this case will be restricted for 40 years. And so you can have a 20-year vesting for the DA, but that DA requires a 40-year commitment that is on title, which can't be broken. So that 40-year requirement isn't subject to the DA. It stands apart even though it's part of the project.
Okay.
Anyone else want to share their thoughts or?
Well, I agree with Commissioner Crandall in a lot of areas because as I go through like page 3, talking about, consistency findings, I can find a lot of inconsistencies, especially when it comes to health safety that have to do with traffic and parking. And this DDA supports, the plan that was talked about last time, and just that there's no place coming out to De Los Mares where the traffic can turn left. you got to go all the way down and make a U, or you got to keep going down De Los Mares, that there's no signal, in front of it, four-way, especially with the office. So when it comes to the safety, and it talks a lot about we've minimized and mitigated potential impacts to adjacent properties, I don't think that's true when it comes to traffic and parking. So, and I just don't like the track map, because neither one can stand on their own, providing their own parking for their use. And this property is big enough to accomplish that, where they don't have to be dependent on each other. That's one of the, and then just the 20-year is a little bit at, sort of that the neighbors could have to put up with the problem for 20 years. And, it says medical office building, but there's nothing in there says that, in the development agreement, says it has to be urgent care. In other words, emergency services, which a lot of older, people had talked about, or urgent services, rather than emergency services. Because there's no law yet that says you can have an emergency room without a hospital right on, the same property. So I find it difficult to recommend approval to the council.
Because we had already voted on the last time, with our comments being attached to the council. I'm in conflict, because if I agree on this, then, and it has the 5%, and we looked at the 8%, and we actually said it could be a little bit higher, but I didn't want to trigger the concessions. But if I agree with this, we're at 5% again. The 8% is not even included, and then, of course, the parking issue. So I'm in conflict, and it seems like we're giving a mixed message to the city council if we approve this as is, and yet we had our concerns on the other issue.
I have a question or two for Mal. Let's assume that the project gets approved, but the DA doesn't. So they have a 3-year window on their entitlement, correct?
Thank you. Cecile.
So I won't put you on the spot. I believe that that's accurate, okay? 3 years is the default on the,
3 years is the default, but they can request an extension.
okay, thanks. So what do they have to do within that 3-year window to solidify or vest their, I mean, on the 2-year and 364th day, can they apply for a building permit? Or what do they do to capture that?
So to vest an entitlement, you have to pull something like a building permit and spend some sum in furtherance of that building permit. Once that's done, it's vested. That's pursuant to a series of cases.
Okay, so let's assume that they pull a building permit at 2 years, 11 months, and then they don't do anything. They don't proceed with the construction. At the expiration of that permit, then would their vested entitlement go away without some reapproval?
So we're playing with hypotheticals here. You have to
Yes.
be careful. So if they pull that building permit and they have invested something in furtherance of that building permit, even if they haven't begun construction, right? But they've invested some money in furtherance of that building permit. At that point, their project is vested.
Okay, and then it's invested presumably in perpetuity?
It's vested.
Okay. Okay, so it's not a super high bar. They don't have to get a C of O and spend tens of millions of dollars building the thing.
The bar is not high intentionally so, as set by the courts in California.
Okay, thank you. If, in the default scenario, let's assume no DA is approved by council, but they get sued for the project, and then that's it, enters into a litigation period. Would the 3 years get tolled during the litigation period, or no? Would it automatically get tolled, or would we have to give them some kind of approving documentation to toll that time?
So the hypothetical is that the city grants the entitlements, and there is a writ filed challenging the granting of those entitlements. So first of all, that writ would be filed against the city. We would be sued. Now, they would be required under their entitlements to defend and indemnify us. But yeah, that would postpone that time period. The pendency of that lawsuit would postpone that time period.
Just automatically without any DA in place or anything?
Yeah.
Okay, thank you. I'll go ahead and share my thoughts. As I kind of mentioned in the other meeting, and kind of was brought up by Commissioner Davis, my experience with development agreements is that there's quid pro quo. My impression, my opinion of this is that we as the city aren't getting enough to justify giving 20 years approval on the entitlement. And as the attorney mentioned, like he was the attorney for Talega. Well, I've seen DAs on much bigger and more complicated projects that allow for 20-year windows to allow for market cycles and complication in development and environmental agency permitting and things like that. But I personally can't recommend a 20-year approval on this without the city getting, in my opinion, substantial quid pro quo, and especially in hearing that the bar for kind of vesting the development right is relatively low. It's not like the building needs to be completed or anything. That's my feeling. I don't like it at all, but I wouldn't want to see, I'm glad there's 3 years. I mean, this is a complicated project. It's going to be complicated to design and do the architecture and get through plan check and all that stuff. So they certainly need that. I could even go 5 years. But beyond that, I don't see that we're getting enough and the complication doesn't justify the long term. Those are my opinions. Anyone else, or I'm ready for a motion? I'll make a motion. I move that we recommend denial. By the way, sorry, let me jump back. I can make the findings that are in the staff report for what it's worth. The proposed findings, they're consistent with the general plan. I would say generally that's true. And that the tentative map must comply with the Subdivision Map Act. That seems, obvious on its face. So I can make those findings, but that doesn't mean I agree with the proposed DA. So I would recommend, my motion would be that we recommend denial of the development agreement to City Council with all of our thoughts being shared to them.
I'll provide the second.
What was the motion?
Recommend denial of the development agreement to City Council.
Denial of resolution PC, blah, blah, blah.
Well, we were being asked to recommend approval. Let's see here.
Staff recommends, the planning commission recommend determining, so we're gonna recommend that we are not, well, what are we gonna determine on the EIR? We probably wouldn't recommend, but we want to deny the second part.
My motion, thank you for clarifying that. My motion, sorry, let me amend my motion. Where's our recommendations here?
It would be positive on one.
Yeah, I would recommend that the, approval of item number 1 relative to the CEQA stuff.
Chair McCann, if I could, if there's a motion that is adopted to recommend denial of the application, CEQA findings are not required. So if in that motion, you just need to make a motion to recommend denial.
Okay, then I'll stick with my motion to recommend denial to the City Council.
I have a question before we
Please.
call the vote. Mal, in the state ordinance for development agreements. They have a process that it has to go to Planning Commission, then it goes to City Council. If City Council makes major changes to what Planning Commission sought, the state says it's got to come back.
So once we've recommended approval to the council, it's in the council's hands. Once the recommendation comes from the planning commission and goes to council, at that point, it's going to be with the council. If there are, I mean, if the entire project changes, then I guess that would come back to planning commission. You typically don't see that.
Because I
So
read that
once-
this afternoon going to that state, and give me a hint, it specifically said that.
Once you've made your recommendation, again, unless there are wholesale changes that
Okay.
require a re-review, that it's at the council level.
And this does not preclude this from going, it advances to council, one way or the other.
This will advance to council regardless of planning
Regardless of
commission's
our-
decision. Approval, denial, recommendation, it's going to council because of the way the code works.
Are there any competing motions? Well, let's vote. All in favor?
Aye.
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 Any opposed? No? Thank you. Good luck.
Yeah.
Ne-
Quick question, can I have a quick question?
Sure.
I was just wondering, like, the last meeting we had regarding this meeting we have regarding this, what is the filter for it to get presented again? I don't want to hear the same stuff over and over.
The items presented at the last planning commission meeting were related to the entitlements to rezone the property and to allow the construction of the development that was proposed.
Yeah.
This was the development agreement, a separate item from those. Unless essentially a new project is proposed, there's nothing left for the Memorial Care Senior Housing Project to come back to the Planning Commission for.
Yeah.
And there hasn't been any duplication of review by the Planning Commission because those applications have all been reviewed, noticed and reviewed by the commission once.
Just want, okay.
Okay, next item of business, consideration of speed cushions on Camino Ferro. And I'm guessing that the most patient girls in the world are here for this item. So they deserve ice cream afterwards, listening to that.
And it
So-
is a school night.
Do we have a staff report?
Yes, we do. Good evening, Planning Commissioners, Chair McCann. Zach Ponson, I'm your Assistant City Engineer. Tonight with me, I have our Senior Traffic Engineer, Ryan Kim. Tonight, we'll be proposing a petition that came to staff for some speed cushions on Camino Faro, which is just on the northeast intersection of Calle Frontera and Avenida Vista Hermosa. If you don't mind, I do have some slides in case anybody needs to see them, and I believe, bear with me, first time using the room, I think it works. So, as you can see, I'm going to go back a couple slides, apologize. This is a public residential street that serves an HOA with several private streets. These cul-de-sacs, this is a local, it's a local street, but it serves as a collector into these other cul-de-sacs. So the neighborhood has gathered a petition, and my understanding, that petition was actually submitted to city staff back in November of 2020. And staff at that time did an analysis of February 2021. The analysis that was done proved that the measurements that staff didn't show that it met the requirements to provide traffic calming measures or speed bumps. So at that time, staff notified the main petitioner, and as my understanding, it kind of sat still at that point. Since that time, myself and Ryan Kim have joined this new role. Our policy actually says when there is a petition, whereas 67% or more of the area actually has voted for it and gave us that and in favor of it, they deserve their day in court. And so we have asked the main petitioner if they'd like their day in court. And although the measurements didn't meet the requirement for the required findings of doing traffic calming, we're here to recommend denial of the speed humps. And we are here for any questions that come up. If you want me to give a brief summary of it, the 85th percentile of speed came in as 27 miles per hour. And then we look at a number of other different measures before traffic calming needs to trigger in. So in our agenda report, we gave you a breakdown of the scoring that triggers traffic calming. This street only received a score of 40, and 51 is what then triggers that further analysis. Staff did also look at our speed cushion policy also. So we have two different policies of traffic calming, and we have a speed cushion policy. Looking at that speed cushion policy, there was a number of different issues on this street that actually make it troublesome to actually add speed cushions. Particularly the curve of it mid-block and the steepness of the street. So the steepness is the biggest one. Technically, you don't like to add speed bumps when you're above 5 or 6% grade. So the one slide I wanted to show everybody. So on the next slide, we show you where we put the speed radar back when they did the study. We saw an average of a little over 1,100 trips per day. This was the score that they received. So we look at things like that speed. We look at the actual volume, the number of crashes. There was one rear end crash noted in that 7-year period, excuse me. We look at things at how close they are to schools and how close they are to parks. And so this one was close to a school and a park, so we gave it both those criteria. And so, and we actually look at if there's sidewalks also. This street does have sidewalks on both sides. This street was repaved back in 2017 and had some traffic calming implementations added at that time. So some of those things that we do, first steps that we do in our handbook of tools is to add edge lines. So that was done a few years back. And then another tool that's in there is to actually remove the center lines. Sounds counterproductive, and I know we got a lot of public comments and emails to where the center lines go. It's actually in the industry as a tool to actually slow people down. So several years ago, staff added the edge lines and we removed that center line. Doing our study, this screen kind of shows the grades of the street. Towards Vista Hermosa, you're up around 10% grade. Through that bend, you're at about 8% grade. And then down towards the lower end, you're just under 5%. And so really looking at speed humps in general, you're kind of stuck. You don't want to put them on that steep part, and then all I have left is this lower part. I don't think you'll be able to see my mouse, maybe you will. We have the lower part down here, which is really right next to the stop sign. And so it's not a place that engineering staff's going to recommend putting in a speed hump. With that, I'm going to close my presentation, and I'm available for any comments or any questions.
I have a question. How many speed cushions? 3?
How many would we recommend?
Yeah, how big would be recommended for that street?
Generally, you would 2 or more
2 or more?
for this kind of
It's like 400
length.
apart, 400 feet apart. I was out there today, and there is an incline and parking on both sides, stop sign. At the time I went, it was very quiet. But I do understand that I could see where, because of on the Vista Hermosa side, that the light would cause someone to skip through there as a shortcut. So anyway, I just wanted to share that I'm familiar with it.
So the speed, little speed, what do you call it, recorder, it's facing westbound, so it's catching the eastbound speed. In other words, people trying to go from Frontera and cutting to go up to Vista Hermosa?
We collected both streets, both,
Both ways?
yes.
Because it only has, see how it's just directed one way? Because is that the cut-through? People going east to avoid the Frontera?
So we did receive a lot of emails about other neighborhoods, but most likely the coast area and potentially these apartments across Frontera potentially cut through. I've actually went out there and sat out there several times myself just to see how many people are coming westbound on Faro and turning onto Frontera, because that would be a good indication that they are kind of cutting through, because not too many people would be coming from your neighborhood and cutting and using Frontera, because if you're going to Ralph's and Trader Joe's, you're going to get on the freeway, right? And so there's not too many people that would cut through other than, I'm going to call it the western half of the coast and maybe this apartment complex across the way.
So is most of the traffic from Frontera on Faro to Vista Hermosa?
If there are people cutting through, it would be the few people that live on Frontera that way. I didn't see a lot of people doing that, actually, making
What
that
time of
movement.
day? Is it like when
I was
moms are
out
taking
there
their
from
kids to
5
school and
to
they're cutting through?
So I was out there during kind of the after-work rush hours, both times. So I kind of went out from 4 to 5 and then 5 to about
How
5:45.
about when school's gonna go in and school's gonna come out? Like when moms are going to get their kids?
And yeah, I'm not sure if our other staff, Jane, if she had been the one who's also been out there several times. I'm not sure what time of the day.
The 1,161, we don't know east or westbound, that's just the total.
That's the total, correct. And that's going to, from my visits out there, I only saw 2 people that were turning on to right out of about 60 to 80 cars. And so I didn't see a lot of people using that Frontera turn, and most people that I observed were turning into the cul-de-sacs. So obviously the people on Frontera, or not Frontera, excuse me, on Camino Faro are going to be the residents that live there. So I can't expect that there's more people cutting through than there are residents. And so in my time observing it myself, I saw probably 2 cars out of a good 30 that were actually speeding. I didn't have a radar myself, but when I drove it too, with the curve and stuff, I personally found it somewhat difficult to go fast.
Both intersections are signalized.
Avenida
Well, not only
Vista
they turn
Hermosa,
in,
correct.
but
Correct,
People on
both sides.
Frontera avoiding Frontera and Vista Hermosa turn up Faro, and that's a signalized signal there. So I'm assuming most are heading to the school to take their kids to, or vice versa, coming back from school and avoiding the intersection, the signalized intersection, and didn't turn onto Frontera to go to where they live. Because you wouldn't cut up there and turn right, wait for a signal, then cut down to Frontera Vista Hermosa again for another signal.
Anyone else have questions?
Yeah, did we just put, was there a petition that we just put like crossing guard there?
We have some crossing guards at the northbound freeway off-ramp, actually.
Just somebody new just got petitioned to go, that's dealing with
That was
Marblehead, right?
rough, we started that this school year. So
Yeah,
that was
yeah,
the
yeah,
first.
yeah.
That was the
Thought there was a
latest.
thing. So there's
That
already-
was,
yeah.
other than we do have a new one potentially out in that Talega school that we're driving.
Yeah.
But the latest addition of crossing guards was on the freeway northbound off-ramp
Got
at
it.
Hermosa.
Okay, and then, to my fellow commissioner's point, is the traffic speed going up the hill, that's gonna be slower than down the hill, possibly, you know? Or is it both directions? Is the calculations from both directions, or is it just one direction?
Yes, it's both direction we're talking
Okay.
about.
And the speed,
Yes, both.
both directions?
Yes.
Yeah. Okay, and then, why is it a problem to put these cushions on a grade?
Ultimately, that could lead to destabilizing a car, I guess, or kind of losing control. So when you're kind of going down a grade, industry standard is to not put them on hills, because that could lead you, and bump you a little bit harder. So,
So if a car's going 25 miles, because that's the speed limit, right? 25 miles an hour right
Right.
there. if it's going 25 miles an hour, you're saying downhill, speed cushion's gonna throw it out of the whack, and that's a liability for the city?
If we start deviating from industry standards and an accident happens, we very well could be facing liability. I'm sure an attorney would look towards something like that.
Yeah, yeah. And I'm just trying to understand where you extract that industry standard. I'm sure you know, but I don't. I'm learning right now.
Yes, the threshold, the maximum grade is about 6%.
Okay, 6, so we got 10, 6, and what?
We have 10, 8, and just under 5.
10, 8, and 6, I got, okay. So it's, and that's a cushion, right? Now, is there other, besides the lines and the removing of lines, is there other speed mechanisms that we could maybe do? You know, like, have you ever thought, like, you know, I travel sometimes and all of a sudden I get the red lights, but it's just a little sign sitting there, you know, and it pop, 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 red lights because I'm going too fast? Is that even an option to do?
You know, you're bringing up an interesting point, because past experience with a lot of these applications, it's really just gone, you know, I'm going to backtrack a little bit, sorry. For decades, the city just didn't really want speed bumps. We didn't have a policy for it, we just simply didn't allow it. And so with the new design of speed cushions where the fire and emergency vehicles can spread their tires across them, we've been a little bit more open to it. So back in 2012 and 13, we developed these policies. And since that time, we've added speed cushions in several areas and several streets. Our policy actually says to look at less intrusive stuff first. And some of those other streets that did receive speed cushions probably should have been going to other devices before they were getting cushions. And so in the next couple of months, you're actually going to see some applications where myself and Ryan are likely going to come to you and probably recommend other stuff before going to those speed cushions, because that's what our policy says.
Well, it sounds like speed cushions aren't even an option.
From a design standpoint here, I have a hard time recommending this one.
Liability standpoint.
Liability standpoint, design standpoint, I don't want to be standing up in front of a judge saying why we put it in when it didn't meet standards.
And then, but there's other options, you're saying that.
The other options, when we see that criteria, that's why there's 2 studies. So we have a traffic calming study that we do first, that we look at these parameters of if they are speeding, we have a toolbox of tools that we'll pull out and say, hey, what can we do to start trying to control these speeds in these situations? The edge lines that were added, the center line being removed is the easy one. So that we do kind of whenever we're repaving, we look at streets and just should we try to do this? The next ones after you do that you're going to probably start seeing a little bit more of is electronic speed signs. And so those are the ones that are on all day flashing at you when you're going 27, they're going to say 27. So those are a little less intrusive than a speed cushion.
Now, can we do a red, is it an option? I mean, I don't know where our policy is, but like red and blue lights that pop off when you're going too fast? I mean, they get my attention, the other ones don't.
No, that's a great question. We haven't gone that far in terms of San Clemente, so we don't have any of those right now.
Yep.
So we have several streets with the electronic speed radar signs.
Yep.
Something like Calle Frontera or Faro would be the first time putting it on a residential street, though. Normally, we just added them on Pedriza just last year. We added bike lanes and some electronic speed signs at the recommendation of Planning Commission. So we added 2 on that street, but it's not directly fronting on homes. So one thing with adding these signs is it's going to end up being kind of right in front of somebody's house if it's on a residential street. And so that's something to take into consideration. So if we are recommending lights, we're going to need written permission and okay from the people's houses we're putting them right in front of too.
Yeah. What about, is it even viable to do a speed cushion down at the 5% area and then maybe a little sign letting them know they're speeding at the top? Just exploring all options, and I don't know if this is.
It's a tough one because it's close to that 5% and it gets flatter and flatter as you get to that stop sign. So at that stop sign, they really shouldn't be speeding, or they just came around a turn.
Right.
And just going.
What's the distance between that 5%? You know, if it's industry standard 5% and that stop sign, if it's 150 yards, then maybe it's, Yeah, is there a definitive line somehow, somewhere?
Yeah, it's tough, because, I mean, from an industry standpoint, I guess what he's saying is, could we put one in between this, how far away would you really want to put it before an intersection?
Not wanna, how far away can we without liability?
Without liability, I would say about 400 feet from the stop sign would be appropriate.
I don't know. That's too vague for me personally. I want to know, like, give me a fact, not a guess on that scenario. Like, you know, we deal with inches, we deal with feet, we deal with yards, like, oh.
Well, I think, in fairness to them,
Yep.
that, you know, you're hitting them with a new question. They
Yeah.
would have to figure out where the slope of the street
Yeah.
dips less than 5%.
Yeah.
They don't know that at this
Yeah,
time.
okay.
I mean, that would be
Well,
something that definitely we can look into type of thing. Actually, I do believe our speed hump policy, and that may actually get into how far do you go to put spaces in between humps, or cushions, I'm trying to say the right word.
Yeah.
He's been saying, to call it cushions each time. So there's a distance in between them that we don't want to put them too close, you don't want to put them too far. And so that's why when you put them on a block, you're trying to put two, not just one random one sitting there. In this particular street, it didn't meet the requirements for it, so staff's going to stick with our recommendations, but,
And this request's been going on 4 years, 5 years?
you know, this one came in, it looks like in November of 2020, and then Ryan Kim, our new traffic engineer, we lost one in February, and then she was only here a short time before, so it didn't look like they got their day in court, though.
Didn't I hear something in 17, this was an issue, or?
That's when they added looks like that's when they added the edge lines and removed the center lines back in 2017.
Because of public comment type stuff?
Either
or-
because of
Well, this
complaints,
has been going on 5, 8 years, 10 years,
potentially.
not more.
Potentially,
Okay, thank you.
yeah.
Any other questions?
We're trying to slow down the traffic, but what conflict are we trying to eliminate? They've obviously got a concern, is it the crossing of the street? Or is it bicycle riding on this street? What are we trying to, we want to make it as safe for the kids as we can.
Right, and I'll defer to
So
those
is there
public
specific
comments. that'll go.
locations? So in public comment, have you all turned in cards? Yeah. Okay, I'll wait till after that.
I will say, a lot of the emails we got talked about just the difficulty trying to leave these cul-de-sacs, and potentially with that curve there too.
So it's while they're in their cars?
What's that?
So it's car-to-car conflict?
And it sounds like we got several, just it's difficult to cross the street. So one thing with this HOA, these are all private side streets. It sounds like they prohibit parking in their side streets at night. So many people have to end up parking out on Camino
Okay.
Faro.
Okay, gotcha.
Commissioner McCacken?
Do you know what's the grade on Valencia and Cristobal, do you know?
Ooh, probably close to 6%, but it probably
6?
varies. It's probably similar to this where it varies. It's steeper at the top as it goes down.
Some is worse, yeah.
Yeah, most of those streets all have that similar topography. So when they put those speed cushions in, I'm gonna hope that they kind of put them further down the hill where it's a little bit less.
They're already in on Valencia and Cristobal.
Yeah, I mean, when they did it, hopefully they pushed them a little bit further down where it's a little flatter. Those streets are a little longer than this, and, but all those staff members are gone that probably put those in.
I have a quick question,
Please.
and then I want to hear from the public. An extra stop sign, has that been considered midway?
Stop signs are not considered a traffic calming device. So stop signs, I'll defer to Ryan, correct me if I'm wrong, are based on the number of cross traffics that you're getting. So you're basically looking at two intersections, and how much traffic is coming out of one of these cul-de-sacs would never meet up the criteria to meet across, to justify a stop sign. And last thing you kind of want to do is add a stop sign unnecessarily, because people will start running it, and then you really get into some, if there's nobody's ever there, they're just going to start running it.
Regarding it sounds like potential car-to-car conflicts and pulling out of the cul-de-sacs, could that be aided and enhanced by extending red curb for improved sight distance?
It's an excellent question. When I was reading some of the emails, we got a lot yesterday and today, and I think you guys saw them. What was one of my first thoughts too is, can we relook at that area and see if we can expand some of the red curbing out on Faro to improve their line of sight? And maybe that would be a recommendation, if you want to, that staff could look into that. If we do increase the red curb, it'll have to come back to Planning Commission and City Council for adoption, because it has to be something that's ticketable and enforceable. So anytime we add red curb or remove red curb, we'll bring it to Planning Commission and City Council.
Okay, thank you.
Yeah.
Any other questions for staff? Okay, we're going to open the public hearing and hear from members of the public. Do we have speaker cards?
Chair McCann, we have a number of cards. I'm going to start with, and I apologize if I'm mispronouncing this, is the Brittain family, or Brittain? We've got Adeline, Chloe, and Tatum, and I don't know who is who, so I'll let you all decide.
So as a reminder, you have 3 minutes each, and when the lights turn yellow, that's like your 1 minute warning.
Thank you so much. Good evening. Thank you for being here. I'm here tonight to emphasize the importance of speed humps to be installed on Camino Faro. There are many reasons why speed humps are necessary. To start, Camino Faro always has cars parked on both sides of the street, which makes it a very narrow road to drive on. The road also cuts through to Cali Frontera, which causes a plethora of cars going up and down the hill every day. Our neighborhood, New Providence, suffers greatly from this. There are so many active people in this neighborhood who walk their dogs, go for runs, and bike daily. This does not just include adults. This neighborhood has a substantial amount of kids who are very active. With Marblehead Elementary being just a jaunt up the hill and Jim Johnson and Shore Cliffs just over the freeway, many of these children are walking or riding bikes to and from their activities. Everyone is extremely afraid when it comes to crossing Camino Faro, my children and I included. The hill curves so you can't even see very far up the hill to see if a car is coming, which leads to my next concern. With the curve, cars parked on both sides of the road, and speeding cars, this makes it very difficult to even turn out of the majority of the neighborhood streets onto the main road. Not only was safety to the pedestrians a huge worry for these residents, but just simply turning onto Camino Faro from their streets is very difficult. To add on, for many families going to work and taking their kids to school in the morning, the sun makes it even more dangerous. It is positioned in a spot that is completely blinding as you're going up the hill. If we can slow the traffic down with speed humps and even put stop signs in, I know it would make a tremendous difference. Personally, my kids and I ride our bikes and scooters almost every day for swim, school, soccer, play dates, etc. We're so lucky to live in such a beautiful place with many activities close by, which is why I love where I live. But at what cost? Is it worth it to show my kids how to live a healthy lifestyle if we're so afraid to get hit by one of those cars coming down the hill? As I spoke to nearly everyone in the neighborhood as I did this petition, everyone had their own stories of how many times they've almost been hit by a car driving down the hill. Please, let's not wait for somebody to get hurt before we make a change. Thank you for your time.
Thank you.
Hi, my name is
Can we
Adam.
restart the clock, please?
Hi, my name is Adeline. I live in New Providence. I ride my bike home from school, and it's scary for me because the cars are going super fast. I hope you will put speed bumps in to keep me and my family safe. Thank you for your time.
Thank you.
You have to say it, okay? Go ahead. If you don't want to do it, you don't have to. It's up to you. Do you want to do it? Do you want to? Yes or no? Okay. Do you want to just stand right here? Here. I'll stand right here and you read it, okay? Go ahead. Do you want to do it or no?
I want to hear what you wrote down.
Yeah.
Tell me.
She's been practicing quite a bit.
Good job.
Why don't you go ahead and say it? Maybe I'll read it for her. This is Tatum. She lives in New Providence. When she walks the dog in the neighborhood, it is scary for her because the cars are going way too fast. Thank you for your time.
Thank you, Tatum.
Good job.
All right, I'll call the next three speakers, and if you could just be ready. Tracy Denny, Carrie Kobayashi, followed by Nancy Noel.
Do I just start talking? My name is Tracy Denny, and I just want to say thank you so much for listening to us. It's quite an emotional, subject that like breaks my heart because, I've lived in San Clemente my entire life, and I've lived in New Providence since October of 1993. I lived above the high school before that when I was little. Vista Hermosa wasn't a through street. It didn't go all the way through. Talega wasn't there. None of that was there. It wasn't a through street. It was closed off at the freeway. You couldn't enter the freeway there. So our neighborhood was built before all that happened, and now the traffic is crazy. I mean, I can't tell you. If you just sit there, when I walk the dogs, you can hear the engines just gun it. From Frontera, they gun it on that first part going up that hill. Don't say they don't, because they do. They fly, and they fly down. And the biggest problem also is trying to pull off of our street, Calle Balandra. When I come out to make a left, you have to like literally inch as far as you can out, and you still are just like, okay, go. Like that's how it is. Chalupa, the street above us, is the worst street. I mean, I don't even want to go on that street if I'm driving a car because I can't get out. So the traffic is horrible. I don't know what time there was someone who said that, it was slow when they were there. Maybe that was during the day when the kids are in school, people are at work. I'll admit it's probably slow. But when the kids are going to school in the morning, everyone through the coast comes through. When I leave my house to go to my father-in-law's house, he lives in Camino de los Mares, I don't get on the freeway. I go out of my neighborhood, I make a, very scary left turn on Frontera, and I go through the coast. And that's how I go. And I'm sure they complain about the traffic. It's horrible. Everyone uses a thoroughway, and it shouldn't be, and we need to do something. Maybe if speed bumps, that would teach them, like the first time, like, hey, we got to slow down. That's the point. What about those little ball things that go on the ground? Those, I don't know, I've seen them before where they just kind of make your tire kind of like vibrate, but they're not going to do severe damage to your car like a speed bump would. And then on Valencia, you're saying that's a graded street similar to what we have. They have speed bumps. And I go down and pick up my friend. She's handicapped, pick her up every single day, and I do errands with her. And I have to go slow because I know that speed bump is there. You got to just, and you see it coming, you're going to slow down. It's a bottom line. Every time I go down the street, I think, oh, I don't want to go down this street. And that's what I'd like, is people not to cut through our neighborhood. I would like them to go around. Take Vista Hermosa, take the signal, but don't cut through it. It's a very small, kids fly through there, teenagers with their cars. You can barely cross. Seniors can't cross the street when they're walking. Our neighbors, we have to walk on the other side of the street because of the coyotes. They're so bad, and there's brush there. So you have to cross the street, or you're also going to be in danger. Thank you. I think I'm done. Anyways.
Thank you.
Give us something, please, but not a stop sign. And no more red
Thank
curves.
you.
Hi, I'll be quick. I'm not a speaker. Anyway, my name is Carrie Kobayashi, and I live in New Providence off of Avenida Marihata, and I've been there for 29 years. And like Tracy said, there was nothing there when I moved there. So the traffic has gotten ridiculous cutting through from Frontera. They just fly going up that hill on Faro. And when I pull out to make a right onto Faro off of Balandra, you cannot see. There's cars on both sides, And it's very dangerous when I walk my dog, when I see the kids coming down from that street, and someone's going to get killed, unfortunately. Something's going to happen because you can't see. And, I know 82% of our neighbors want these speed cushions, and I'm in full support of the speed cushions, And the school, too, with the children coming, they're riding their bikes, and like Tracy said, like people trying to cross the street with all those people parked on, because the people across the street in the apartments, they park there, and we're not allowed to park on our street. We have to park in our driveway or in our garages. So if you have an extra car, you have to park. So there's not enough space, there's not enough parking for a lot of people. So anyway, I just want to say thank you for listening to me, and hopefully we can get something done here. Thank you very much.
Thank you.
Thank you.
Good evening. My name is Nancy Nowell, and I live on the street that Tracy said is the worst one, Chalupa. And it's the worst one because the street curves, Faro curves right before my street, and there are large cars, large vehicles, vans, big trucks, all sorts of vehicles parked on Camino Faro, and you literally cannot see around them. You just inch out, and when my husband pulls out, I look one way, he looks the other way. I say, clear. I remind myself of my parents. They used to do that all the time, but it's necessary to get out of our street. It's very frightening to try to pull out, and cars just go whizzing down the street all the time. I see them going fast up the street, but what I see mostly is they just tear down the street, and it would be so easy to get broadsided. I have almost had that happen numerous times. It's frightening. I walk my dog every morning. We have two. My husband takes one, I take one. And we walk down Faro, and the cars are just tearing down there. It's scary, and you are concerned about the liability of putting a speed cushion in, sir, whereas the liability is much greater of something happening the way it is now than if we had a speed cushion and somebody went over it and maybe had an accident. They maybe wouldn't have kill somebody, though. And I think one of these days someone's going to get seriously injured or killed. It's very dangerous. Thank you.
Thank you.
All right, next speaker, Bert Sandin, followed by Kevin Thomas.
Good evening, I'm Bert Sandin. I'm one of the board members there at New Providence, have been for, 12, 13 years. The entire board is in support of speed bumps, is anxious for them. I can't remember a time when the board wasn't. Years and years ago, maybe 10 years ago, we even had a traffic engineer that when we approached him regarding this, told us we had a problem because he liked the idea that cars coming down Vista Hermosa, he liked the idea that they could cut through our neighborhood and relieve traffic at the light there. That traffic does come down that hill fast. I don't mean to say that your findings aren't correct, but I've lived there 32 years now, not a few times parked with my car. That's a lot of speed coming down there, and I know when I even pull out of my street, which is not the bad one Nancy lives on, I pull out a little bit, look both ways, pull out a little bit, look both ways, pull out finally, and hope that I don't have to jump on the gas really hard to get out of the way. It's dangerous. I even had an opportunity to buy a house on Chalupa years ago because it's a single loaded street with the best views. my kids were coming up into the age where they were going to be driving soon, I decided I wasn't going to buy a house on that street. I did not want my teenage daughters trying to drive and turn out across that street. It is that dangerous. When you say you have average speeds that create the metrics for why you would want to have this, and that we had a 27 mile an hour average and you wanted 32, that's just an average. I'm not worried about the person going 20 miles an hour. That was the low end of that measurement. I'm worried about the guy that's going 40. He's the one that's going to create the accident, even though my average may only say 27. The 27 mile an hour thing is not the issue. It's the person who's going too fast. And whether or not a speed bump would be dangerous, yeah, a speed bump might be dangerous under any condition if someone's driving too fast. If the speed bump, it could be a soft one. If it slows them down, it gives people a margin of error when they're trying to drive out of that neighborhood that gives us the safety we need. Please think about the safety of the people in there. He mentioned that we had a 2/3 vote and thought that it warranted that we would have our day in court. Earlier, is Gary, he mentioned that the people are sovereign. If we had 2/3 of our people in our neighborhood who wanted it, unless I'm mistaken, 2/3 would get us a constitutional amendment, and that's just about impossible. I hope you'd listen to the people of that community. 2/3 is a lot, and we would like to be safe. We, for years, have been wanting this.
Thank you, Bert.
There we go. Thank you.
Okay, my name's Kevin Thomas. I'm also a long-term 33-year resident of the neighborhood. But unfortunately for some of these people, I'm the fly in the neighborhood ointment. I was also a police officer for 36 years. And for 3 of those 3 long years, I was in charge of our traffic division, okay? And so in the course of my career, I read probably in the neighborhood of 10,000 traffic collision reports and signed off on them. And I made some notes here, and you stole my thunder, sir. So you talk about an industry standard, and I get that's your language, but perhaps I can fill in some of the blanks. What happens when a car addresses a speed bump, okay? So if this is the speed bump, the front end of the car raises up, okay? It's actually unweighted as some of the weight is pushed to the back. Okay, and then as the car goes over it, the opposite phenomenon happens. Now, if we go with the 27 miles an hour, it's not very fast, except on a street like this, okay? I think it's probably the average 40-foot wide street. 36, okay. Wow, that's less. So you put a car on one side and a car on the other side, there's 16 feet, and if they've got a foot of cushion there, that's 18 feet. That's half of the road width is taken up by parked cars. So that 27 miles an hour is somewhat enhanced in that small, I mean, you really have to focus and concentrate when there's, oncoming traffic, because there's not a lot of passing room there. But speed bumps are unfortunately not the answer, because that unweighting, even at 27 miles an hour, when that front end gets unweighted and then comes back, if there's any movement of the steering wheel, that's coming back forcefully, and that's going to cause that vehicle to veer one way or the other. And it's going to cause collisions with those cars parked. Now, I don't know if you pulled the collision statistics for the roadway for a certain, it doesn't appear that it's an overwhelming amount of collisions. I don't see them. I don't see the remnants. I don't see a lot of, the after effects, sideswiped, vehicles still parked there, broken glass, all that. So I was here to beg you not to do it, because I think it would be a significant hazard, a much more significant hazard than any, slowing of traffic that it could perform. Hope I was able to fill in some of the blanks there. Thank you.
Thank you, Kevin.
That was the end of the speaker cards that I have.
I believe everyone here has spoken. There's no other unspoken people. Okay, with that, I'll close the public hearing and open up commissioner discussion.
Got a question for Zach. What did Camino Faro do before Mr. Hermosa went through? Did it still make the connection at both ends? Was it a dead end? Was it a cul-de-sac? What was it?
I may need to defer to somebody on this. I should know this, I've lived here forever.
Maybe.
Yeah, like, you know.
Hermosa was a pedestrian bridge.
But there wasn't a Mr. Hermosa there.
Yeah, and there was no freeway on-ramp, so
The only way to get to the neighborhood was from Frontera.
So on the connection to Hermosa was
Okay.
a cul-de-sac?
It ended there.
It ended, so.
So it probably had bollards up or something at the end with
With
antici-
our,
Well, it ended with the recognition that someday Mr. Hermosa.
okay, and it worked, it functioned.
Yeah.
With our safe routes to school policies, does that open up any additional, I mean, this seems like a good candidate to be a focus area for our safe route to school policies. But, I mean, in an extreme solution, which I don't even think you could pull off, you could make it one way, uphill. If you can get enough support for it, and you might even be able to get parking, and a bicycle lane. Because there's only 1,100 trips a day, which is not excessive. But then all traffic would be uphill. And a thought.
We would definitely have to come back to council, or planning commission.
Oh, well, of course, of course.
We would petition
But it
that,
might be
ask for
something
HOA
that they could,
consideration.
talk amongst themselves and,
It is narrow, so having it one direction, I mean, the parking on both sides narrows the, yeah, and then you have that curve. And as I was driving up today, an oncoming car was coming down, and we both had to negotiate around each other. That does slow down the speed, but then you're not seeing that car as it comes down. So
because I think
it's
with
very
with the
narrow.
onset of the electric bikes and all, you were going to get a lot more kids riding on the road. And if there's not enough room to get between the car and the parked cars,
Yeah, I was trying to figure out
it's an
some way to
so
slow
this
it
might
down.
just free things up.
I mean, it is something staff could look at. I would say with one way, you're gonna have a lot wider of a travel lane though. So it,
Well, I was saying if something was designated for the bike lane, it would narrow it'd be
it would
single
feel, it
lane.
would feel like a single really wide lane.
Yeah.
So that could actually lead to increased speeding in that one direction though, from that, if it's the uphill, that
Okay.
morning traffic. So it is something staff would have to look at and consider. It's an interesting point.
And I'm sure traffic goes slower uphill than downhill. 'Cause, driving down, what is it? Veracruz? I mean, you got to ride your brakes to go slow enough to get by that school.
That's why the water officer sits there.
I mean, the residents of the area, I mean, this has been their priority for many years. And it seems like we could, the speed bumps may not work because, again, it is, we're up against the industry standards, but there has to be some other solution to slow this down. And to be able, so that they could get out of their side streets.
I'll jump in here because I have a perception. I heard testimony that there was a bunch of parking at the west end of Faro from the apartments, people crossing the street to park there. So do we have permanent parking districts in the city?
We do. Yeah, we do. There's a couple of them. They're out there. It requires, I believe, planning commission and city council approval. If there's an HOA, definitely it would require HOA approval. We would definitely look at, if it's a matter of congestion of parking on a street, which it normally is, we would look at why they're not allowing parking on these private streets at night, though. So that'd be one question staff would ask of the HOA of, if it's due to too many cars, then why aren't they allowing cars on those private streets?
It seems to me that we, based on the testimony I've heard, we clearly have a sight distance problem, especially at Chalupa, but based on what I saw on the map. So a recommendation that I would have is to go back and reconsider and look at those sight distance issues all along Faro there. And then if you have a significant overparking problem from the apartments that's causing a lot of congestion, then maybe a parking district would help on that. Those are some of my thoughts.
Who allows the parking on that street? Is that an HOA street? That's an HOA arterial.
We're here tonight because Camino Faro is a public street. All the other surrounding cul-de-sacs are HOA private streets. So it's actually interesting that Faro is not potentially if it was today, I would probably request it to be a private street.
It's like in Talega, the arterials, like you can't park in any, at least in my neighborhood, anywhere where it's going up. It says no parking all along, except where there's a little park. How is this parking allowed? There's no house that fronts on any of this. Why isn't it just like a HOA arterial where there's no parking?
It's almost the opposite of Talega, is I think what you're hearing.
HOA allows it, or the city
Since
allows
it's in
it?
their original CCNRs, it sounds like that there's just no overnight parking.
Because I see two issues, it's parking. Plus, if at nighttime you could park there, well, shoot, I'd park, if you can't, if you're trying to avoid some kind of a violation, then you park out there instead of on your driveway. That's one of the issues. The other is speed. The other thing on this little point system, if the traffic is going east, I mean, if it's not school, people are probably trying to cut through to go to Target. That'd add another 5 points. And if you're taking your little kid to soccer, that's another 5 points to Avenida Vista Hermosa. That would give them to 50 to have speed bumps. And they'd only be 1 point short. So I think a solution, one way, it sounds good, but I don't know any other one-way street anywhere. And that could be kind of confusing, because then you're going to have to post no right turn coming down Vista Hermosa and coming across. You're either going to have to put bollards so that they know that they're not going to turn down, they're going the wrong way.
Well, we'd have to change the intersection, we'd have to get rid of the left turns, there'd be some significant cost on
I'd rather
that.
see talking to the HOA or whoever we need to do to say either red curbs or no parking and give them a bump or two. Maybe not. Or maybe start with talk about the parking so that you can see people, see cars, and red curb it. But I do think where the people are going, besides the school and the small Marblehead Park, I would say during the in-between schools, there are moms going up there to get up to a little bit farther, like Target.
Commissioner Davis?
Yeah, so I got a couple things. I really feel that the future of e-bikes and kids commuting is gonna be humongous. And I'd hate to see a white bike out there. That would just really bum me out, You guys know what I mean by the white bikes, right? So then, I would like maybe if you could engage with the HOA and see what their thoughts are on loosening their restrictions on parking for their community, because I have a feeling a lot of that parking is from their own HOA. If it is a safety concern, maybe there's enough pressure from the residents to loosen that a little bit and let them park in front of their house. We used to live in the reserve. I remember it was like, man, there was a pretty serious problem. My son got towed like 3 times in a month, So that might be a concession from y'all's neighborhood. I know it's not pretty, but it might be something. You can shake your head, but we don't want somebody getting hurt. I'm not gonna engage, sorry. So then there's, so what about considering instead of, well, I just want to explore all options, but maybe there's no parking on one side of the street. Would that help? Like, I guess there's a bunch of bushes and coyotes on one side, maybe parking on the bushes side of the street and no parking on the other side, and open up a bike lane somehow, I don't know. But, I'm just trying to explore ideas here. Maybe there's safe routes to school policy that, I don't know anything about it, but my wife's Lisa Davis, and she's the local trustee, and she's easy to get a hold of if you guys want to collaborate with her and see maybe there's something that the school district has in place to help with whatever needs you might have to get to the end goal. I don't know. I'm just spinning ideas, but I get what they're saying. And then one way uphill maybe, but That's about it. I don't know. But I don't want to table this. I want to address it. Like, let's bring it back to court, as you said.
Can I ask staff, is there anything else aside from the padded bumps that would be in the roadway that would slow down traffic? Any
I
alternative?
mean, our traffic calming manual's pretty thick. I mean, it's 38 pages, and there's a number of things in here. You can bottleneck streets with curbs, you can put islands in there, you can do a lot of different things. Obviously, everything comes with a cost, though. And so, narrowing streets or putting raised crosswalks or traffic circles or roundabouts and one-way streets and bottlenecks and chokers is what they're called. And so you can redesign the whole curbs, but now you're talking into the hundreds of thousands of each street that comes in and to do this. This is an emotional topic, obviously, that we hear about daily from a staff level. There's not a person in the city who doesn't think people aren't speeding on their street. And they're organized enough and smart enough to get their petition going, and she did really well getting a really high percentage of the people on our street. And so it's something everybody feels passionate about, and we have this, guidebook to tell staff which direction to go with our tools. Right now, I don't see a lot of other tools in there that, from a without redesigning and narrowing the street with bulb outs and all kinds of things, that's something that council's gonna have to approve in a yearly budget. It's that big. And so that's not something that we're gonna be able to handle in our traffic calming budget, that's for sure.
Go
ahead.
Zach, there was a street kind of the same configuration off Veracruz. And there was a lot of concern about people picking up the kids. And they either changed the parking, this was probably 5 years ago, 6 years ago.
Ricciello?
That might be it.
Off of Ceramentosa potentially.
Yeah.
So I believe that was a little bit different. The HOA may have paid for their own speed bumps in that case, and, because it didn't justify it. And it was a little bit different of a time too, when the speed humps weren't designed like they are today. I don't know all the details of it because I wasn't always in the traffic department, but I know enough growing up here. Growing up here, so I know enough about all these projects.
Okay.
That one's a little interesting. It's all single-family houses in a big loop with one street across the center. So it's a little bit different because this is a feeder street to a bunch of private cul-de-sacs. And so
And
this is
are
a pretty
any
unique
additional monies
situation.
available when something's designated a safe route to schools? I know around, Maxburg Park, there was work done or money spent for the safe routes to schools.
I don't know if those bulb outs at Maxburg, that is an interesting example, though, of potentially it being used on anything other than sidewalks. A lot of the safe routes to school is just adding a sidewalk where there's a missing gap. And so connecting areas to, the upper high school campus, for example, is a safe routes to school where we've added a sidewalk in. I could look into the Maxburg Park to see if that was used for that. Because other than that, I know mostly it's just filling in sidewalk gaps and getting the kids to school. But is there other options? That's something we could look into.
Yeah.
What if you had no left turn from Frontera onto Faro? Like how what street is that that's next to, we just talked about it the other day, we're on El Camino Real, you have the yellow, bollard so that people can't turn left down their street.
Yeah, on Esplanade,
Yeah,
little
what if you had-
delineators out there.
But
No left turn.
But residents want to get into their neighborhood to get home.
Well, but they could just make another approach. If they're worried about people coming up, but that doesn't take care of coming down. I really think that I'd start out with red curbs so that you could at least see. And then I think we could work out the points to where they can get 51 to get speed bumps.
I, for one, I'll just go on the record, I'm not supportive of speed cushions here, because it doesn't meet the criteria. It's not that I'm not sympathetic to your beautiful kids and families, and I'm sure there is a problem with this, with the high-speed people. The city's established criteria so that they can try and create some evaluation criteria as to where it's applicable. And the traffic engineering industry has established criteria relative to grades and so forth. So, based on what we're presented with, you don't meet criteria for the point system, for the speed average, or for the grades. That doesn't mean you don't have a problem. I think that, my opinion is cities should still consider, exploring it. My impression is, like I think some of my other, is that parking is a problem. Sight distance is a significant problem. I like the idea of even considering removing, parking all on the inside edge of that whole thing. So just putting it on the other side. I like the idea of working with the HOA to try and get parking on the side streets. No one's talked about enforcement, speed enforcement. I assume that that's already been done, but that we could do some speed enforcement and ticketing out there on a repetitive basis. If we found out that there was a real problem from the apartments, and they're creating a lot of the parking problem, considering a permanent parking district, but based on the criteria that the city have, I can't, my personal, and I'm one vote out of however many are here, I can't support the speed cushions. But it's not because I'm not sympathetic to your situation. That's my opinion.
See, we're just making a recommendation on this, right?
Technically, if it's not an approval recommending going forward with speed cushions to council, then it's a denial of that petition. You can direct staff, though, to look into red curbing or any other thing. All those features that you kind of mentioned would all be things that would have to come back to planning commission for implementation, though.
I see your hands. Mel, I see hands raised in the audience. Normally, they've had their chance to make their comments. Is it appropriate to
Normally, there's only one chance for comment. That's always chair's prerogative. The rules of order dictate that there's one chance for comments, but the chair and commission can always override rules of order.
Okay. I guess I'm inclined to, I see 3 raised hands, to give them each 30 seconds to hear what they have to say based on our discussion. Is that okay with the commission?
Yeah, it's a safety issue, so certainly.
Okay, so please each be brief, but we'd love to hear what you have to say.
Eileen, do you need their
Would
name
you mind
and all?
coming up to the microphone? And Chair, would you like a timer on this?
It's up to you.
I'll keep a timer of 1 minute each.
This is more of a question, accepting that we can't have it speed bumps, and that it was mentioned that maybe they could get together with the community. How do we proceed with possibly the board meeting with planning staff to see what other options might take place? I know the community will not want to remove parking on one side. Making the red on both sides of those turns would probably help, because then you could see up the street and not be blocked by the cars that are parked close to the curb. But we're not going to be capable of parking on our streets. Just change the CC&Rs is near to impossible. So how would we proceed with trying to find an alternative that may work?
Thank you for your comment.
If someone could just tell me who I email or something like
Yes,
that.
yeah.
Ultimately, I can meet with you guys after this outside if you want to wait. And give you my cards.
Thank you.
I was just going to say that these are the people of New Providence that want it. It's 82% of the people that want something to slow the cars down because they feel like they're in danger. So many people have kids that walk home from school, and I look at these kids and they're like, okay, ready, run, go, run. And it's so scary. Somebody's going to get hit by a car. It's, these kids, there's not parents that can be home to walk their kids home from school every single day. So to keep our neighborhood safe, and these people and the people that are walking their dogs and riding their bikes and scooters, these are the people that are that can get hurt, that can get killed. It's so dangerous, honestly. I have one more child at home. I know he wished that he could be here to speak as well, but it's so scary. I can't stress it more. Like, we need to do something about it. 82% of the neighborhood wants to do something about it. So clearly there's a problem. Clearly. Thank you.
Thank you.
Okay, so I just wanted to say that I feel that one of the biggest problems is just the flow of traffic coming through our neighborhood. It's not even, it's just if we could slow it down, you know, deter people from coming through our neighborhood constantly, deter those people cutting off of, you know, Vista Hermosa heading west and making a right into Frontera. They're just cut through. I mean, they cut through and I see them. They don't even stop at the bottom of Frontera. They just roll through. The other thing that I want to say is no speed bumps. How about just those little bumpies? You know, when you're going, they want you to slow down. They're bumps. They're just a little thing like this, and when your car goes, it just goes. You know, it's just something in the road, you know, that says slow down. Even if it's lines in the road, maybe that does it. You can't hit something, it's just flat, you know? Do something like that. And we already have red curbs, and they even extended the red curbs. That's not even the problem, and that's not going to solve the flow of traffic. The flow of traffic, the amount of people that cut through our neighborhood is the biggest problem we have. And we can't afford to lose any more parking spaces. And people in Highland Line,
Thank you. Your
they
minute's
also
up.
park in
Thank
our
you.
neighborhood.
To answer your question, those are called bots dots, and then they can create noise issues for neighbors. So the neighbors that are next to them have a tendency to not like them, because then they hear a noise every single time a car drives by, 1,100 times a day. Anybody else have any thoughts or want to make a motion?
I'll go ahead and see if we can do this. I don't even know if it requires a motion, but I think we acknowledge there's a problem. I think we are probably in agreement that speed cushions may not be the solution, but I think we want to recommend to staff to accept the public outreach to try to come up with a solution, because I think it is a safety issue for the kids' safe routes to school, very important to this city, and that we do whatever we can to get the residents working with staff to come up with a viable solution that we'll do it as quick as we can. Let's move it up on the priority list.
I could second that.
Can we add a timeframe to the meet of with the staff within 30 days? I mean, I want to tie the.
We can try, but I mean, to be perfectly honest, we have several petitions in front of us, and council even just last night directed me to prepare reports on one that we're not even done with. And so I'm supposed to write a
So
report.
realistically, I mean, these people came
I
here
mean, we
tonight.
can do our best to meet with HOA and with their availability and ours. What we usually do is organize community meetings with those HOA members and invite people down, similar to what we did with Calle Frontera a couple weeks ago. And we had about 40 people show up and talk about what can and can't be done. In this case, the HOA really should be in that room as a board. Whether it's them setting up a meeting and having me come and do a presentation to their HOA as a formal item, or something a little less formal. So that's where it's tough to set up those timeframes for that. I don't know how often they meet as a board or stuff like that.
So what would you suggest is a good time? I want,
I mean,
45 days?
if the direction is to meet with their board, I need to kind of know how often they meet. And so if they don't meet but every 6 months, then I'm tough to kind of get something formal, because what I don't want to do is meet with one board member and have that be the board's opinion.
Yeah.
And it not being a formal board official thing.
My opinion is that staff is,
work
extremely
with them.
professional,
Okay.
and we can trust them that they're going to do it in an appropriate and expeditious timeframe relative to
It's a
the-
tough one, because we just got directed last night to potentially rush another one.
Yeah.
And so everybody's is going to ask for a rush, and at some point, you're putting somebody at the end of the line who's just as critical on their street. So it's always a tough battle to it's a very emotional issue. I mean, it's a
Say,
tough one.
we just say it's a priority, and we know that there's a problem, and Zachy is very good at getting the work done.
Yeah.
Great. Can we make, I really like your idea, I think I like your idea of the one-way street. And there are a couple in
Yeah.
San Clemente that are already one-way. And maybe that's the solution everybody's willing to deal with. It's gonna limit the traffic, it's gonna keep parking on both sides, make some dedicated e-bikes, because we're gonna have a big e-bike issue that I think should be part of the thoughtfulness of this whole thing.
I mean, and I will respond to that too. To me, it's the bike paths and bike pedestrians, so I'm not gonna separate e-bikes and regular bike paths. So the potential to try to get a class 2 in there, which is a separated definite bike lane,
Yeah.
whether or not it's e-bikes or regular bikes, engineering, I kind of don't differentiate.
Right.
But we can look into these things with that HOA. So ultimately, a request from really the public or that HOA to either red curb, the line of sight is something we could look into. Adding entire red curb to that south side is something that really should come from the HOA as a petition. It's really their street that serves this whole thing. It's almost surprising, like I said, that it's even a public street. Growing up, I kind of always thought it was a private street. And we can work with the HOA though and see what kind of thing they can do, because they need to make their residents happy too and be in agreement on what comes forward.
Chair McCann, if I could chime in on one thing.
Please.
There was some discussion about the Planning Commission's determination on this item. There is a question before the Planning Commission, and that is, should the Planning Commission forward a recommendation to the City Council? A vote to either deny the public's request or to not forward a recommendation to council, it would be nice, rather than not voting on anything. With that, that is the actual question at hand here, not provide direction to planning, to engineering staff to do any other particular work. However, what I would recommend as a kind of quasi-compromise was maybe in a month and a half, at the next meeting, after a month and a half from this time, I can come back if Mr. Ponson doesn't have another similar item on the agenda, to give an update on exactly what the work that our engineering staff is doing with the HOA to work on some of these identified issues.
Okay.
I will alter my comment so, as stated by Adam.
So to be clear, your motion is to not forward a recommendation to the City Council that they add speed cushions on Faro.
And study it more.
Yeah.
And as part of that, staff will return with, I'll say, the first meeting after a month and a half from this time, with an update on where that work lies, what's being done with it, and
I
so
would agree
forth.
if we don't say deny, just say at this time, we do not forward. You know, should the planning commission forward a recommendation? And at this time, we wouldn't forward it, but refer it back to the traffic division to meet with the residents of the HOA to develop a solution.
So there is a petition that is before the planning commission that needs some type of resolution. If you're not going to deny the petition, then your only other options are to continue this item to either a date uncertain or a date certain. Understanding, though, that if the reasons for being not in support of the petition are not going to change to another meeting, meaning the standards by which the engineering division has provided their rationale for a recommendation for denial are still going to be in place, which I think we can say are probably going to be the case over the next, 2 to 5 years, then there's really no point to continue it. We'd rather complete this project and have staff work with the HOA to identify other avenues of, no pun intended, of solution.
I will withdraw my motion and accept an alternate motion then.
Your last motion to, your motion based on what I had said would work. So it's a determination not to forward a recommendation to city council and an understanding that staff will return, I'll just say within 2 months, to be simple, within 2 months to the planning commission with an update on what engineering staff is doing with the HOA on alternative measures that may be employable in this
My
scenario.
motion is to follow Adam Atami in this recommendation.
And specifically 2 months?
It will be within 2 months.
Within 2 months?
Yeah.
Is
For an
one
update,
cushion still an option? I mean, you know, on the 5% slope, would that do anything?
Staff's recommendation would probably be, it ends up being too close to that stop sign down there. Because you got to give advance warning from people turning onto the street before that speed hump, speed
But
cushion.
we don't know that distance, though.
According to my previous research and measurements, it was probably about 250 feet from the stop bar to the possible locations.
So is that not a good idea? How, like, what's the distance, the gap between them generally, do you like?
Generally speaking, it's recommended to put it in 400 feet apart.
So, okay, 400 feet apart, that's 200 feet from each one. So 450 gives you benefit or no?
I'm looking at our little exhibit right now, I just don't, looking a couple hundred feet up from that intersection probably gets you into that grade where you're already above 5 and close to 6%. Because that's where you have to have warning signs before
I'm
it.
asking for more specifics, I think that you don't quite, we didn't ask that before, okay.
I'll second your motion, Commissioner Crandall. And I'm open to alternate motions if there are any.
So the motion is to not forward a recommendation and to let the engineering staff meet with the HOA and the community to try to find a solution.
And report back within 2 months.
Okay, I'm in favor of that.
I think the community needs to be heard, and I think the staff is willing to work with the community. There's going to be questions about the parking. I like the one-way. I know you don't want to lose your parking either. I understand that. HOA needs to be involved there. The site issue is a site with the red curbs, but yet then when that happens, somebody's going to be losing their parking. Permit parking should be considered. So let's regroup and not forward it. And so I would agree with that. And let's get everybody back to the table and try to come up with a solution quickly.
Just for what it's worth, you know, we're talking about potentially one-way. I personally am not supportive of one-way, or at a minimum, I would want to see it studied a lot more, because I agree with Zach. I think that people would go a lot faster, because they'd have a perception of I'm not going to have a conflicting car coming the other way, I've got a wider travel lane. So, in general, the engineering professionals and traffic engineering professionals are much more versed and studied on the issues, and then the consequences and implications of what that is than we are. So in general, I defer to staff's expertise relative to those issues. That doesn't mean that I think we play a very important role in, trying to explore all the options, but just as, I would not be in support of one-way unless I heard a lot more from staff that it was a good idea and would achieve the desired result. So with that said, all in favor of the motion?
Aye.
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 Any opposed?
And he'll be back before us.
Yes. Thank you for coming. I'm sorry it's not the outcome you wanted. Old business, there's no old business. Reports of commissioners and staff. Does anybody have anything to report or they'd like to comment on?
I do have a couple items, Chair, but I will wait until the commissioners have
Okay.
shared their reports.
Nothing to report?
Nothing to talk about? Okay. Adam?
Yep, okay. So I am flipping to the tentative future agenda that is provided towards the end of your packet. Just want to give a couple updates on some items. The first is that the city's housing element has been approved by the California Department of Housing and Community Development, which is a major step necessary to in maintaining compliance with state housing laws. This was a very large effort that was spearheaded by our Community Development Director, Cecilia Gallardo Daly, and so I want to report out on that. In response to some of the programs that were identified in that housing element update, the Planning Commission will be seeing some items in the very near future, specifically November 2nd, the housing element rezoning program is slated to be presented to the Planning Commission. And that rezoning program carries out some of the policies and programs identified in the housing element. Additionally, at that next November 2nd meeting, we will have a specific plan amendments for 5 of our 7 specific plans. This is a project designed to create consistency between our general plan and our specific plans, and this includes the Rancho San Clemente specific plan and Talega specific plan provisions previously discussed related to auto uses and encouraging those in the business park away from El Camino Real. So that's going to be coming up. Let's see, in addition to that, last night at the City Council meeting, the West Pico corridor specific plan was adopted, the ordinance was introduced by the council. And this was approved by the commission about a month and a half or 2 ago. And just wanted to follow up on the one item where the 3 lots were discussed as being added to the West Pico corridor specific plan. That was also approved by council, so the expansion of that specific plan area will occur. And then the last thing, we just want to let everybody know we have a new senior planner that is going to be starting in the planning division on November 1st. This is a management position, and they will be overseeing the functions of our current planning activities. You know Sarah Toma, she is our senior planner. She will be handling our long-range planning functions. So this is the first time in the year that I have been the Deputy Community Development Director where I actually have 2 senior planners overseeing both sections of the planning division. And then also, just so everybody's aware, we have a new code compliance manager position that's starting. That's another position that has been unfilled for the last 14 months or so since I vacated it to become the Deputy Community Development Director. That position is now, will be filled. That position also starts on November 1st, so that'll be a really busy week for me. But all of that's to say that both of these recruitments will really help free up a lot of staff time to start addressing some other issues, and as well as my time to be able to focus more entirely on the planning division. And then one thing for our design review subcommittee members, granted one, and our alternate is here. There is a meeting scheduled for November 23rd, which is right before Thanksgiving. There's nothing on the agenda right now. If there's any desire to not hold that meeting, or if there's an understanding that members will be absent, it's most likely there won't be enough. Yeah, just let us know. We can discuss this at the next design review subcommittee meeting. But I want to put that on your radar in case that meeting, it would be better to cancel. And that wraps up my report. Thank you.
Adam, I have a quick question. How many positions do we have open as far as building department inspectors, that are needing to be filled at this time?
The building division, I'm not sure of.
No, we're not fully staffed there.
I believe, honestly, I'm not sure exactly where that rests at this point. And the reason for that is that the building division can rely on contract inspectors and plan checkers rather easily because they're all reviewing the California Building Code. I don't know exactly where that is today, but I can find out and follow up with you.
Just seeing where we are from where we started.
Yes.
Thanks.
Okay, thank you, Adam. Next item on the agenda is adjournment. Do I have a motion to adjourn?
Motion to adjourn.
Second.
All in favor?
Aye.
Any opposed? The meeting is closed. Until the next